Welcome to EUPrivacyForAll, Session 33 on GDPR, Article 37, Designation of a Data Protection Officer. Article 35 on the designation of a Data Protection Officer was finally renumbered Article 37. It sets forth that the controller and the processor shall designate a Data Protection Officer where the processing is carried out by a public authority or body, where the core activities of the controller or the processor consist of processing requiring regular and systematic monitoring of data subjects on a large scale, or where the core activities of the controller or the processor consist of processing on a large scale of special categories of data. A group of undertakings may appoint a single data protection officer. Where the controller or the processor is a public authority, a single data protection officer may be designated for several such authorities. Additionally, the controller or processor may, or where required by union or member state law shall, designate a data protection officer in cases different from the one mentioned in paragraph 1. The data protection officer shall be designated on the basis of professional qualities. It also may be a staff member of the controller or processor or fulfill the tasks on the basis of a service contract. The controller or the processor shall publish the contact details of the data protection officer and communicate them to the supervisory authority. In Recital 7 of the 15 December 2015 GDPR draft, it was specified that the mandatory appointment of a data protection officer was deemed acceptable in strictly limited cases. In Recital 77 of the final draft, adopted in May, it was mentioned that guidance on the implementation of appropriate measures and on the demonstration of compliance, especially as regards the identification of the risk related to the processing and the assessment of those risks, could be provided in particular by means of approved code of conduct certifications, guidelines provided by the board, or provided by the data protection officer. In different provisions regarding an obligation to communicate contact details of the DPO, the GDPR stresses that the DPO is a key tool in the compliance to be demonstrated by controllers and processors. Such is the case regarding the information of the data subjects in Article 13 and controllers' records of processing activities, or also regarding notification of a personal data breach, prior consultation of a supervisory authority, or in the frame of BCR's assessment. The Directive 95/46 framed the exercise of the activity of data protection officials, mentioning that it should act in complete independence, that member states may provide for the simplification of or exemption from notification based on the appointment of a personal data protection official, and refer to prior checks regarding the existence of data protection official. What should accountable data controllers and processors get prepared for? First, controllers and processors will have to assess whether they may or shall designate a data protection officer. Controllers and processors shall designate a data protection officer if, being a public authority, if the core activities of the controller or of the processor entails regular and systematic monitoring of data subjects on a large scale, or if the core activities of the controller or the processor consist of processing on a large scale of special categories of data. A group of undertakings may appoint a single data protection officer, and the data protection officer shall be designated on the basis of professional qualities and expert knowledge. The controller or the processor shall publish the contact details of the DPO and communicate these to the data protection authority. The data protection officer must be consulted to carry out data protection impact assessments to help to identify risks related to the processing, their assessment and best practices, and how to mitigate those risks. Controllers and processors shall finally communicate the contact details of the DPO to inform data subjects in records of processing activities, to notify data breaches, and to handle prior consultation and binding corporate rules. So EDPB guidance on mandatory designations will be absolutely crucial.